So friends, 180 is the number of the day. Special Counsel Jack Smith just filed a notice with Judge Tanya Chutkan in Donald Trump's federal election subversion case in Washington, D.C., seeking permission to file a, quote, oversized brief of 180 pages. Why? Well, because Jack Smith says that's how many pages he's going to need to reveal all of the evidence of Donald Trump's January 6th crimes. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So first of all, friends, let me tackle the obvious issue, my voice. I am fighting what feels like a losing battle with bronchitis. No, I'm not trying to sound like Barry White or the late, great James Earl Jones, though I wish I did sound more like them. I am at a point where I'm just kind of mainlining hot tea with lemon and honey, trying to keep this at bay. So if I burst into an uncontrollable coughing fit, I'll just go ahead and edit that out. Okay, let's turn to the issue of the day. Jack Smith finds himself needing to file a mega brief to reveal all of Donald Trump's crimes and conduct in relation to his attempt to try to overturn the results of the 2020 presidential election. And it's his responsibility now to file this brief so that Judge Chutkan, who is the presiding judge in Donald Trump's federal prosecution in D.C., can do exactly what the Supreme Court told her to do: litigate all of this and rule. Rule on which of Donald Trump's crimes and conduct might be the official acts of a president of the United States, such that he can't be prosecuted for it, and which of his crimes and his conduct were clearly unofficial acts, so he can be prosecuted for it. That brief is due to be filed by September 26th. But there's a little wrinkle with respect to when that filing by Jack Smith, presumably he'll file it on or before September 26th, when it might be publicly available. And that new wrinkle comes courtesy of something that Jack Smith included in his 2-page notice that he just filed with Judge Chutkan, asking the court's permission to file this mega brief, 180 pages. So let's start with the new reporting, and then let's turn to the very short 2-page filing by Jack Smith. This from MSNBC's Deadline legal blog: why Jack Smith wants to file an oversized motion in Trump's federal election prosecution. Special Counsel Jack Smith wants to file an oversized motion in Donald Trump's federal election interference prosecution. It's the sort of request that might be unremarkable in a typical case, but Trump's opposition to it underscores its significance. Smith's request came in a court filing Saturday to U.S. District Judge Tanya Chutkan, who's presiding over Trump's Washington, D.C. criminal case, and now faces the complex task of figuring out what the Supreme Court meant in its July ruling granting broad criminal immunity to the Republican presidential nominee. The Republican-appointed high court majority told Chutkan she must determine in the first instance which of Trump's alleged actions are immune from prosecution under the new immunity test. And now, friends, let's go right to Jack Smith's new 2-page court filing. In the case of United States of America versus Donald Trump, the pleading is captioned, "Government's opposed motion for leave to file oversized motion." In Trump versus United States, the Supreme Court emphasized the necessarily fact-bound nature of any presidential immunity analysis. And then Jack Smith quotes the Supreme Court opinion. Determining whose characterization may be correct and with respect to which conduct requires a close analysis of the indictment's extensive and interrelated allegations. The analysis, therefore, must be fact-specific and may prove to be challenging. Knowing, for instance, what else was said contemporaneous to the excerpted communications, or who was involved in transmitting the electronic communications and in organizing the rally, could be relevant to the classification of each communication, meaning as official or unofficial. The Supreme Court remanded, meaning sent the case back to Judge Chutkan, remanded to this court to determine in the first instance, with the benefit of briefing we lack, whether the defendant's conduct in this area qualifies as official or unofficial. To fulfill the Supreme Court's remand directive, in a status hearing on September 5, 2024, the government proposed filing an opening immunity brief with a comprehensive discussion and description of both pled and unpled facts, meaning facts that were already disclosed in the indictment and facts that weren't. Those would be the unpled facts, so that all parties and the court know the issues that the court needs to consider in order to make its fact-bound determinations that the Supreme Court has required. The government also indicated that the proposed brief would include a substantial number of exhibits. In a scheduling order entered the same date, the court ordered the government to file an opening brief on presidential immunity by September 26, 2024. The court has been directed to conduct a detailed, fact-bound, and thorough analysis of the government's case to make appropriate immunity determinations. Because the court will make determinations in the first instance that will be subject to exacting appellate review, it is essential that the court ensure that the record in support of its determinations is complete. The government believes that a comprehensive brief by the government, the prosecutors, will be of great assistance to the court in creating that robust record, and the government thus seeks leave to exceed the typical limit for a single motion, which is generally limited to 45 pages by rule of the court. The government has substantially drafted its opening motion and estimates that the filed version will not exceed 180 pages. The government estimates that roughly half of its motion will consist of a detailed factual proffer, and that extensive footnote citations to an exhibit appendix increase the motion's size by more than 30 pages. The government conferred with the defense, that is, with Trump and his attorneys. Defense counsel opposes the government's motion at this time and requests that the court set a deadline of September 24, 2024 for the defense's response. Why do Donald Trump and his lawyers oppose this motion? Why do they not want this mega brief to be filed on September 26th? Obvious reasons. Donald Trump doesn't want the American people, the American voters, to know anything more about his crimes or his conduct. What he did to try to unlawfully and unconstitutionally retain the power of the presidency after he lost an election. He doesn't want anyone to know any more about that before people go to the polls on November 5th. But friends, there is a kicker here, and it's on timing. Because all along, once Judge Chutkan set the filing date of September 26th, we thought, okay, that's when we will see this brief filed. It will be publicly available, and we will learn more about Donald Trump's crimes and his conduct. But at the very end of this short 2-page notice that Jack Smith just filing is a little bit of a curveball on the timing front, meaning when will the public get to see this motion that it looks like will be filed on September 26th? Here's what Jack Smith says, and then I'm going to try to translate it from, excuse me, I'll edit that out later. I probably won't. Then I will translate it from legalese to English. So At the very end of this two-page notice, here's what Jack Smith says. For the court's awareness, the opening brief and its exhibits contain a substantial amount of sensitive material as defined by the protective order. Consistent with the protective order, the government intends to file a motion for leave to file under seal that attaches an unredacted copy of the motion and appendix and proposed redacted versions to be filed later on the public docket at the court's direction. Because of the extensive and time-consuming logistics involved in finalizing the brief, appendix, and proposed redacted public versions of the same, the government respectfully requests the court's decision on this motion as soon as practicable. Okay, friends, now the translation from legalese to English, and I read that paragraph a dozen times just to make sure I fully understood the sort of procedural ins and outs that it seems Jack Smith is suggesting. Here's what it boils down to. This is what I think it means. It sounds like on or before September 26th, Jack Smith will file two things with Judge Chutkan. An unredacted 180-page motion where everything is visible, and a proposed redacted version of the 180-page motion to redact out, black out, sensitive material. What is sensitive material? Well, it will take at least two forms. One, anything that involves classified information. There's still some minor litigation over some possible classified information that is part of Trump's D.C. Federal prosecution as compared to the classified documents prosecution down in Florida, where it's all about classified information. So that sensitive material can be classified information, or I have a feeling much of the sensitive material may also involve ongoing criminal investigations, because remember, there are still 6 unindicted co-conspirators that we learned about in the not one but 2 indictments that were issued in this case. And I have a feeling sometime in the not too distant future, we may see more federal indictments of more individuals, the command structure of the insurrection, the suits of the insurrection, not just the boots of the insurrection. So it looks like what Jack Smith is saying in that final paragraph is he's going to file an unredacted version so Judge Chutkan can see it all, a proposed redacted version, blocking out, blacking out anything that is sensitive and shouldn't be revealed publicly. And if that blacked out version, that proposal, is acceptable, then Judge Chutkan can go ahead and authorize it to be filed on the public docket, and that's when it will become publicly available to everybody. I have no idea how long that process may take, but Judge Chutkan, I'm sure, will take it up in due course and do what she believes is right without regard to an election cycle, because Judge Chutkan has said in court repeatedly, and I think I've been in court in D.C. every time, live, and I heard her say it, that her case will not yield to or be dependent on any election cycle. But I did want to add that footnote at the end, because it may very well be the filing will be received by the court on September 26th, but we may not see any of it until some future date. But friends, stay tuned, because I think between now and the 26th and in the weeks after September 26th, all of this is going to be rapidly developing. And friends, even though this has been a long and rocky road to accountability, I have to believe that we are going to get there. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.